Well, good morning again, ladies and gentlemen. Thanks for joining us. This is the second session in our property pick and mix. I know some of you may have joined us this morning for the first session with Richard Lander. And if you have, apologies, I'm just going to quickly run through the format and a few do's and don'ts and things. I'm Nigel Clayton. I'm a property lawyer, a member of the Business and Property Group at King's. Later on today, Matthew Hall is joining me. We're going to make some introductions to the various topics. We have a team of barristers here, and we also have a guest surveyor who's going to be speaking at 3:30 as well. As I mentioned this morning, it's, of course, that time of year when we normally hold our flagship property conference, which is usually a half-day conference at a hotel where we all get together and catch up. And we can't do that, so the property pick and mix really is intended to be the next best thing. It was a brainchild of Geraint Weekly. Sadly, he's not here, he's tied up in court, and that means as well that his slot at 2:15, he was going to be speaking with John Hunter, one of our planning lawyers, is unfortunately postponed. But we've got a full format. I'm going to introduce Nick in a minute, but just a reminder, after Nick, we've got Wilson Horn at 11:30. That's an overview of disclaimer, freehold and leasehold. At 12:45, we've got Emily Duckworth, adverse possession after Dowse and Bradford MBC. At 1:30, it's myself, proprietary estoppel. We're skipping Geraint and John's talk at 2:15. 3:30, we've got John Thompson, our surveyor, just a review of the property market, what's happening, what's likely to happen. 4:15, Eleanor Darcy and myself speaking about mortgage litigation and undue influence. And then finally, last but not least, of course, Dr. Nathan Smith, 5 o'clock, the session on leasehold covenant. So quite a mixed bag, I hope, there. And as I mentioned first thing this morning, just a few obvious pointers. These are Zoom webinars. Each session has its own login. So at the end of each session, it will close down. And if you want to come on to the next session, you'll have to log in separately. As you can see from the screen, most of our presenters, I think, are using PowerPoint slides. Nick's put his up already. There may be some switching to and fro, so do bear with us. And finally, please feel free to use the chat function or the Q&A function at the bottom. We're largely dependent on time. If Nick finishes in good time, he'll no doubt cast his eyes over the chat and the Q&As. If you've got any brief comments or observations, by all means, throw them in, brief only, please, and we'll do our best to sort them out. So that's it on the intro. I'll turn straight over to Nick Taylor. Nick is a brand new tenant at King's Chambers. He joined us in September 20 after completing his pupillage. He's a member of our Business and Property Group. Don't let that belie the fact Nick has had a thoroughly busy background. You'll see from his super impressive CV on the Chambers website that, in fact, after getting a double first at Cambridge, he qualified as a chartered accountant with the corporate tax team at one of the big four. So he brings a wealth of commercial and accountancy background to this position. So Nick's talk, I'll hand over. You can probably see from the title, Possession During the Pandemic. Nick, we briefly mentioned this. It's a difficult topic to cover, and there's been a lot going on, hasn't there?
Yes, thank you, Nigel. Thank you very much for the introduction, the kind introduction, and thank you everyone else for joining today. Yes, welcome to this talk on possession claims during the pandemic, and welcome as well to this branding. This was billed as a pick and mix seminar format. I can't say I was expecting to see that reflected in the PowerPoint template, but here it is. Now, if I'd been giving a talk on possession a year ago, well, firstly, I'm sure it wouldn't have been on Zoom, and secondly, I doubt there would really have been much new to say. But as Nigel has indicated, possession law and practice is one of the areas which has perhaps seen the most change since the start of the pandemic, both legislative, practical and procedural, and that's what today's talk is about. So what will we cover today? Well, firstly, I will very briefly touch on the background to the stay, what's been going on since March of this year. Secondly, I will cover the new Practice Direction 55C, focusing in particular on the concept of reactivation notices, what they are, when to use them, and what to include on them. Thirdly, I will cover the overall arrangements, again, what are they, and focusing in particular on what they tell us about the practicalities of how possession proceedings will be prioritised, listed and heard. Fourthly, I will briefly cover the change to notice periods in residential claims. Not in exhaustive detail, you'll no doubt be relieved to hear. More to highlight the fact that they have changed and point towards really where to look in that respect. And finally, I will cover the area that still represents probably the biggest moving target, how enforcement is currently being dealt with, and in particular, in light of the fact that we are once again all subject to a national lockdown. Now, 30 minutes is clearly not long enough to cover all of the changes in this area. So this talk is certainly not comprehensive, but it will hopefully at least provide an overview and highlight areas of particular interest. So with that framework in mind, we'll move on to the first topic, which is the background to the stay. I've titled this Historical Background, somewhat tongue-in-cheek, as the events of March this year, some senses feel like a very long time ago. I don't spend long on this, as it's clearly been superseded, but in summary, 27th of March 2020 was the key date. All possession proceedings were automatically stayed by the pilot Practice Direction 51Z. The stay was pretty comprehensive. There was a slight relaxation for cases such as trespass claims against persons unknown. And in fact, such a case provided one of my very few trips to an actual court building during the summer. And although the stay did not prevent claims being issued, clearly little would have been achieved by doing so in practice. As you can see there on the slide, the stay was extended twice by CPR 55.29 and was extended finally until the 20th of September 2020, at which point it ended. Now, clearly this would not be a talk by a barrister if there were not some case references, and I would not want to be the one to disappoint you all today. So I've highlighted here three notable cases which did deal with the stay. Firstly, the Hackney case, which confirmed the scope of the stay applied to proceedings up to the Court of Appeal. So the stay really was quite extensive. Secondly, the Arkin case, which clarified that the court did have the jurisdiction to lift the stay, but that it would only do so in exceptional circumstances. To my knowledge, and probably unsurprisingly, there were no cases where the court did lift the stay. And finally there, the TFS Stores case, which confirmed that the stay applied to proceedings not commenced under Part 55, but that were brought within its ambit, in this case by virtue of a counterclaim by the defendant. Now, do these cases tell us anything of lasting importance or interest? Probably not, as the circumstances of the stay were really quite unique. But clearly the thread that binds all of these three cases together is the fact that, well, in my view, the courts got the message, the intent of the government at the time, in that the stay was intended to be fairly insurmountable, given how unprecedented that period really was. Each of those cases can be seen as the court buttressing the scope and effect of the stay against challenge. Now, we are not in that time anymore, and as we will see, the stay has been lifted. But the wider context is that it is certainly clear that things are not back to normal. And in my view, it is very likely that the courts will recognise and continue to ensure that the new possession regime is, where necessary, buttressed against any, say, speculative challenges. So that's the background covered. Where are things now? Well, the stay did come to an end on the 20th of September 2020, unlike, say, the winding up petition prohibition. It's not been extended again. And although I'm very reluctant to make any predictions at all, it is very difficult to imagine the stay coming back. As we will see, what will probably continue to be tweaked is the procedure and enforcement of possession proceedings. So they will make it more lengthy and perhaps difficult, but I cannot see any appetite for continuing to let the backlog build up. So what we have now, and the world we exist in now, is this interim practice direction 55C. That applies now and did apply from the 20th of September 2020 until the 28th of March 2021. So that's the world we are in. So what Practice Direction 55C introduces is the concept of reactivation notices. Now, these are very important. They are simply a notice. They are not an application notice, so there's no court fee required. What they do is confirm that the serving party wants their possession claim to be kicked back into the system. They are, in effect, a practical way for the courts to start listing cases again, and will help them to focus on cases which are still live and also focus on cases that warrant priority. There is not a prescribed form that has to be used. So if the correct information is provided, it could all just go in a letter, but there is a standard form that can be found at the link which I've put there on the slide, and that is what really should be used. It is what the courts will be expecting to see. Frankly, there is no reason not to use it, and if it makes the court's life at all easier, they really will thank you for it. I should say forms actually, as there is one form for claimants and one for defendants, but I will really focus on the claimants form as it will be far more common to use and see that. Now, the meat of the reactivation notice is what I've put at the third bullet point on the slide, and it's the requirement to set out what knowledge the serving party has as to the effect of the pandemic on the defendant and their dependents. Now, it's important to say that there is no duty of inquiry here. The key word or the key phrase is what knowledge the claimant has. And in some, and maybe many circumstances, the honest answer might be none. However, if you look at the guide form, and if you go to the link and look at the guide forms there, there is guidance on the form itself, and just read from that. I'll just read from that for a second, because it says, part of it says, if you have no knowledge, you could consider taking reasonable steps to find out before using this notice. Now, in my opinion, that is almost certainly far more than merely a gentle suggestion. Reasonable steps is likely the key phrase there. So although there is clearly no obligation to undertake exhaustive inquiries, it is almost certain that district judges will want to know what steps have been taken to try to contact the defendant and find out what their situation is. It is reasonable steps, and I appreciate that really any inquiries will add costs and possibly time. But this really is a case where going above and beyond the bare minimum is something I would recommend. It may often be the case, especially with private residents, that defendants could be very reluctant to provide personal information about how they have been affected by the pandemic and how their dependents have been affected. Although with some canny defendants, they may well take the opposite approach. But nevertheless, it would be very sensible to evidence, having contacted the defendant, evidence as to what was asked of them and how you tried to contact them, even if they never reply. And I really think that is one of the more important takeaways from this talk. There will clearly be a significant backlog of possession proceedings, and you really don't want to give the court or judge any reason to adjourn or decline to list a hearing because of a failure to undertake reasonable investigations at this stage. Because to get it back into the system, once those investigations have been made, and even if they don't lead anywhere, may well take really quite a while. Now, clearly the most effective way of finding all of this information out will be a matter of trial and error. And it may be that best practice is already being developed among solicitors. But at a minimum, I would suggest something like a simple letter or email with pro forma questions, asking about employment status, income level, whether the residents have received or started to receive any income support, any health effects of them on the pandemic, etc. And whether they can also provide any evidence of that. At a minimum, I would suggest that would be a good idea. What else does the reactivation notice need to contain? Well, it will be clear from the guide form used, if you look at it. 3 other common requirements will be: firstly, if it's a claim based on rent arrears, the claimant must provide an updated rent account for the previous 2 years. That's clearly quite a significant requirement in some senses, but it is a requirement. Where there were case management directions made before the 20th of September, there's a requirement to attach a copy of those directions and a draft order if further directions are required. And finally, there is a tick box checklist of factors which can be ticked, which will assist in prioritising the cases. I've put an extract of that list on the next slide, so just to move on to that now. You will see there from the slide, it's fairly clear when each of those would apply. I would just highlight the one of potential interest is the extreme rent arrears one, the second down. I will come back to that a little later. There is an obligatory other box at the bottom, which may provide an opportunity to be a little more creative with some circumstances that may warrant your case having priority consideration. I've struggled to think of many examples which may warrant another, but clearly there will be some, and I would say I don't think you really need to be afraid to use that box, as the court will look at the information provided and will be able to take a view. Reactivation notices need to be used during this interim period we're in, so until the 28th of March 2021. They apply to all possession claims brought on or before the 19th of September 2020, except for the 2 examples given there. So the first is claims brought on or after the 3rd of August 2020, and the second is claims where you have a final possession order. Now, although these 2 exceptions will apply to a relatively small number of cases, and although this fear of mine may prove unfounded, there is potentially a clear risk of them falling through the cracks if the court is busy listing cases on the basis of reactivation notices. So it may be good practice, if you have a case which falls into either of those 2 categories, to write to the court, explain that it's not required to use a reactivation notice, you haven't completed one, but that you would like the case to be relisted. What happens if you fail to file a reactivation notice? Well, firstly, there's still plenty of time to do so. You have until the 29th of January 2021, although bear in mind the requirement to set out the knowledge you have as to the defendant's circumstances on the form. If you don't do it before then, the claim will be automatically stayed again. So you will then need to formally apply to lift the stay. This shouldn't be too difficult in practice. The stay is not a sanction, and so there will be no application for relief from sanctions required. But clearly, again, at this point, the backlog will be ever growing. So again, best practice really is to get in early where possible. And finally, is there anything else of interest within Practice Direction 55C? Well, there's a few key points here on the slide. Firstly, the standard 8-week period between issuing claims and hearing them, which would normally lie under 55.5, does not apply. That's a practical response really to the backlog that will exist within the courts. Secondly, if the reactivation notice is filed and any hearing is listed or relisted following that, the parties will be given 21 days notice of that hearing, so plenty of time. And as well, for those claims brought after the 3rd of August 2020, so claims where a reactivation notice is not required, there is still a requirement to serve prior to and produce at the hearing a notice setting out, again, the knowledge of the effects of the pandemic on the defendant. So again, it's a requirement which really extends to all claims to sort of find out what effect the pandemic has had. So that really covers the second main topic, being the new Practice Direction 55C. and reactivation notices, but that leads on to and links in with the next area, which is the overall arrangements, as they are called. So what they are really is just a document which was signed off by the Master of the Rolls, but produced by the courts. It's too large a document to go into detail today, so I do want to just focus on the two areas I've shown here. However, I've included a link to it there, and you can also fairly easily find it if you search for it. I'd suggest that it probably is worth reading in full. It's only around 14 pages, and it will give you a helpful sense of how cases will be listed and other procedural and practical points. So focusing on those two points there, firstly, how will cases be listed? Well, although as a practitioner I've got used to remote hearings, for possession hearings it seems fairly clear the default will be for face-to-face hearings, which is understandable given that defendants are often litigants in person. That said, there are remote or hybrid options, and if the parties agree or wish for it to be heard remotely, it appears the courts can arrange that. The days of the block lists are probably gone. For substantive hearings, they'll be listed for 15-minute slots with time allowed either side for all of the necessary social distancing. And it also appears clear that there's intent to use full-time district judges at the start to ensure there is consistency of practice across the different courts. The overall arrangements document also discusses this concept of case marking. Now, it's not entirely clear how this will work in practice. It essentially appears to be the process whereby courts will or can prioritise cases for listing purposes or even highlight their suitability for settlement. I've said here that it's pandemic focused, but I think it's important to stress that that does not just mean for the benefit of the defendant. What I mean by that is that the overall arrangements makes clear that the claimant, as a landlord, can say that, well, they have suffered hardship by not being able to get possession and that the case should be prioritised on that basis. It appears that any party can apply for the case to be case marked. In the example I gave, the landlord would clearly need to provide some evidence as to the hardship they have suffered. But it nonetheless appears to be a way by which priority can be given to cases which might not fall into the usual reasons for priority. In terms of how cases will in fact be listed, it's essentially something of a two-stage process. It appears that the first real step will be what's called a review date, and there are bundle filing requirements for the claimant around 14 days ahead of this review to be alive to. It's not a hearing, but it does appear to be a date on which the defendant will have the opportunity to go to court and obtain legal advice, say from a duty advisor. The claimant does not necessarily actually need to come to court on that day, as long as they're contactable, say by telephone, to discuss the case with the advisor and perhaps either settle it or agree future directions. The judge will have an allocated 5 minutes to look at the file on that day and make or approve any directions if necessary and if those have been agreed. But I should stress that is simply all done on the papers. There is no hearing. The next step is around 28 days after the review date, what's called a substantive hearing. I say substantive, it's actually 15 minutes. But nevertheless, a substantive hearing listed before a judge. Again, just to stress, the overall arrangements document does make it quite clear that the courts will be considering adjournment of that hearing, even if the defendant does not request it, where the defendant has not been able to take legal advice, or where, given the pandemic, the effects of the possession order will be serious. So, as I've said here, I think it will be quite a low bar to adjournment, but nevertheless, it won't be in every case. So, given all of that, how will the courts prioritise listing these cases? Well, we've already seen the various boxes that can be ticked on the reactivation notice form. Ticking any of those is likely to give the case some sort of priority. It's not quite clear how they will be given priority within those cases, but for entirely understandable reasons, cases with probably allegations of domestic violence, illegal occupation, etc., although in the minority, will probably be given the most priority. The extreme rent arrears, which I touched on earlier, is an interesting one. I won't read out the requirement there, but you can see it there. Now, it might be a difficult one to determine in practice, and the courts clearly won't be doing any investigative work themselves. But if you did have a case where a landlord was desperate to obtain possession, and you can evidence that requirement, then it may be an option. And then the document says, subject to the above, i.e. the long list of priority type boxes, claims issued pre-March 2020 will be given priority. Now, given that probably few claims were issued post-March 2020, that will probably include the majority. So that really is a quick trot through some of the more relevant aspects of the overall arrangements document. Again, the takeaway is probably to have a look through it, as it also has some useful example timelines of how cases might be listed and heard. But it does remain to be seen what will happen in practice. So as well as all of that and all the procedural changes, the fourth area of this talk is covers the changes to notice periods that need to be given for possession claims. This is not an area I want to spend a long time on, frankly, because it's not very interesting, but also because I really don't think there is actually much of a substitute for looking at the relevant guidance and finding out what notice period is applicable to your claim and how it has changed. I've set out here some of the relevant legislation. So essentially on top of all the usual, for example, the Housing Acts, there is now a whole raft of primary and secondary legislation to wade through and that modifies those notice periods. Probably the most relevant is the third one down, the regulations, which I'm not going to read out, but they must also be read in conjunction with the Coronavirus Act and the relevant primary legislation. So it really is probably cold towel on the forehead time. Just focusing briefly on the common Section 8 and Section 21 notices under the Housing Act 1988, as these are often seen. You'll see there that I've put in capital letters and underlined 6 months. That default really is applicable for many of the usual grounds for possession. Focusing on the grounds 8, 10 and 11, as there is some interest, the usual rent arrears grounds. If there is less than 6 months rent outstanding, then it's this new 6-month default. But you'll see there that if there is more than 6 months rent outstanding, the notice period is significantly cut down to 4 weeks. So there may be certain cases where if the outstanding rent is approaching 6 months, it may actually be beneficial to continue to let it accrue past the 6-month period and then benefit from a significantly shorter notice period. All of this will be very much case by case, but it really is something to be alive to and will require careful consideration in each case. For Section 21 notices, the no fault notices, there is the 6-month default applies, but interestingly, the period of validity for issuing proceedings has been extended from 6 months to 10 months. So, as I say, that's very whistle stop, but really it is best practice to assume the notice period has changed. In most cases, it will be longer, and you simply need to have a look and see how it has changed. Finally, the last area I want to discuss today, again briefly, is enforcement of possession orders. In short, if you do have a possession order, as things stand, although as ever there are exceptions. Now, to show how fast moving this area of law is, we have new regulations which are shown there at the bottom. Those were only laid on the 16th of November, so Monday of this week, and they came into force yesterday. In effect, what they do is put the first 2 bullet points on that slide on a proper footing. As you can see, the way in which enforcement was being stopped was essentially through a letter from the Lord Chancellor to bailiffs asking them not to enforce possession orders for Tier 2 and Tier 3 areas and for a month over the Christmas period. We all then fairly quickly went back into national lockdown, and again it was clarified that there would be no enforcement while national restrictions were in place. And notwithstanding the sort of that as a policy decision, it's a fairly questionable legality or lawfulness for the Lord Chancellor to simply write a letter. I did have a 20-minute piece on the legality of such a letter and the prospects of the judicial review challenge. Well, perhaps the Lord Chancellor anticipated this talk, I don't know. But in any event, there are now yet more regulations, which are those at the bottom, which neatly sidestep the lawfulness challenge, although importantly, they only apply to England. In short, those regulations expire on the 11th of January 2020, and before then, no possession orders will be enforced. There are carve-outs, as ever, and exceptions as ever, for the usual serious case of domestic violence and illegal occupation, etc. And interestingly, there's another rent arrears carve-out, this time for what's called substantial rent arrears, those being at least 9 months arrears on the date on which the order was made. It will not be easy to really determine those in practice. All of those arrears must be pre-March 2020. So in a meaningful sense, they are really pre-pandemic rent arrears. So any rent arrears which have continued to accrue since the 23rd of March 2020 do not count towards that 9-month criteria. And given the probable complexity of determining that, it may require an application to the court rather than just a simple request for a warrant to really get an eviction in those circumstances. But nevertheless, there are, as ever, exceptions. So that concludes this talk. I think we're just doing okay for time, and I'll have a quick look at questions now to see whether or not any have come in. But I have put my email address there, really, just to say that if you do have any questions or anything else you want to discuss following this talk, really do feel free to send me an email. But I think I need to possibly stop sharing my screen now, just to have a look at those questions. But the slides will be circulated, I think, later as well. So my email will be on there as well, or you can find it on the website. But let me just now have a look at the questions that have come in. Nigel Day, does this apply to mortgage possession cases? Sorry, I'm not exactly sure what this is. Presumably you mean generally, yes, it does. And in terms of enforcement, again, yes, it does, although there may be specific areas in terms of mortgage possession which are worth looking at. Raj K, whilst the bailiff appointments are stayed until the 11th of January, during this period, can High Court officers apply to transfer up to a writ? Again, I'm not sure off the top of my head. I suspect, given the overall scope of this pandemic, it will be, and the way in which things are going, I suspect you may be able to apply to transfer up, but I doubt you'll be able to get much in the way of an eviction before then. I think that answers all the questions that have come in. Tegan, I've just seen that your audio connection failed. Yes, I do understand that a recording of all these talks will be available, and as I say, the slides will be circulated around. So I don't think there are any other questions. Again, thank you all very much for attending and for your time. I understand the next talk is Wilson Horns, and I hope you enjoy the rest of the day if you are attending any more talks. But in the meantime, thank you, and I will now end this talk from my perspective. Thank you all very much.